South Africa's second national state of disaster will be contested in court. Now, the new declaration aims to avert the total collapse of the grid while Eskom continues with load shedding stages. Joining us now is Tracy-Lynn Field, who is the Professor of Environmental and Sustainability Law at the University of Wits. Thank you so much for making time for us, Prof. So this state of disaster on energy is being challenged in court. Can we use previous judgments on the challenge to the first state of disaster to get a sense of the likely outcome of the current challenge? Because there's that principle of judicial precedence.
Absolutely, Clement. So the government, we've just recently emerged from the COVID-19 state of disaster, where the government obviously used the Disaster Management Act to deal with the pandemic, and a number of cases were brought to challenge those regulations. And one set of cases in particular around the prohibition against tobacco are useful because they tell us what is the quality of rationality that you need to prove that these measures are necessary for the government to justify that they are in fact rational.
Mm-hmm. But a legal challenge to the load shedding declaration or regulations is not restricted, I imagine, to an argument based on legality, because the organizations challenging them could argue that, for instance, the definition of disaster in the Disaster Management Act does not extend to a government-caused load shedding crisis.
Absolutely, and I think that's going to feature very prominently in these challenges. The Disaster Management Act actually talks about a sudden or progressive natural, we're obviously not talking about a natural disaster here, and a human-caused occurrence, and then there are other criteria. So a lot of the argument is going to be about whether this is an occurrence. And I think it's a very far stretch to say that the load shedding disaster is an occurrence in the ordinary sense of the word.
Mm-hmm. So a state of disaster normally allows government to pass these sweeping lockdown regulations that encroached on human rights, whether directly or indirectly, including whether it's the right to dignity, privacy, freedom, or even security of the person and the right to choose and practice a trade or occupation freely. How different are things going to be with this state of disaster on energy? Because I imagine load shedding regulations are not so much likely to encroach on human rights to the same extent as we have seen with the previous COVID measures.
Absolutely. In fact, probably the only right that is going to be affected is the right to environment, because many of the measures are around streamlining or being exempted from some of the environmental requirements relating to energy generation. So most of the measures are around what I call fixing Eskom, or fixing the lack of investment in generation and transmission. So whether that is appropriate to use the Disaster Management Act for that purpose is something the courts are going to have to engage with.
I want us to use one example on the BAT case when they took government to court. The High Court had held that the minister had to show that the regulation was necessary and not merely sufficiently rational. So the courts also needed to reassess this evidence objectively, not on the basis of whether the minister subjectively believed a measure was necessary. So using this test, the court declared the tobacco prohibition invalid. Is that something that we can look at as this new declaration of disaster is challenged, the similar principle?
Absolutely. So some of the court challenges are about trying to get the documentation that the decision maker in this case is the head of the Disaster Management Center and Minister Dlamini Zuma, what was in their mind when they made this decision. And if the minister herself didn't subjectively believe that this was a measure that was necessary, then it fails even at that low bar about a subjective interpretation, or that there must just be some rational connection. But the precedent from this British American tobacco case from the Supreme Court of Appeal is that it must be objectively rational. Everyone must be able to see that it's rational. And the minister, it's not just her subjective opinion that counts.
Yeah. So is the standard high, Prof? So for the organizations that are challenging the load shedding, disaster declaration and its regulation, what should they be aware of? What do they need to note?
So the standard is high for government to prove that these measures are objectively necessary for the purpose that they're trying to use them for. So, in my opinion, there is, there are good grounds to challenge these regulations on the rational connection test.
All right. Tracy-Lynn Field, Professor of Environmental and Sustainability Law at Wits University. Thank you so much for making time for us.